Hello, welcome back to Hunt and Hunt's Litigation. Well, we'll call them the Explainer video series, where we dig into what it is, the language that the lawyers are using when you might get confused about them. Today, we're going to look at the ADR process, or the Alternative Dispute Resolution process, and what the lawyers are doing and the various steps required. But we'll treat this as maybe something that you can do on a step by step, and at some point in time, you'll stop and you won't do the other parts because mediation or negotiation will have solved the problem. But to get through that process, we've got Catherine Ballantyne, who's the head of Hunt and Hunt's Hunt and Hunt's litigation service here in Melbourne. So, Catherine, how does it start? Like, how's the initial advice come about, and how do you scope it out and work it out?
Well, often it starts with a letter of demand. So often one party is wanting something from another party or feel they've been wronged. And it usually starts with a letter of demand saying, you've done the wrong thing. Usually pay up, sometimes return goods, sometimes it's something along those lines, but there's a demand as to what you want. Once you've done the demand, then it might go to a mediation, there might be a negotiation, or it might end up in litigation.
Do you find a lot of people stick their head in the sand when they get a letter of demand? I'm just going to ignore this and it'll go away.
Yes, unfortunately. And I always say if you get a letter of demand or you get something like if you are a director of a company, you get a statutory demand or you get something from the ATO, especially called a director penalty notice.
Mm.
You have to be very, very mindful that there are very strict timelines. And if you stick your head in the sand and you miss those timelines, you cut out a lot of the arguments and a lot of the options for you. So it is never a good idea to just stick your head in the sand.
And it might not cost you a fortune to have your letter of demand reviewed, might it? So, I mean, somebody could come in and it might be simple to deal with it. It might be complex, but it might start something. But more importantly, like as you say, just don't ignore it. I mean, we lawyers can help you solve your problems quicker than you can.
Absolutely. You have to remember, often you're an expert in your field, and I wouldn't profess to be an expert or try to do my own plumbing, for instance. Whereas lawyers are expert. We do this day in, day out. We know the strategy, we know the law, we know what works, what doesn't, what a likely outcome is going to be. So it's often a lot more cost effective to get lawyers involved from the start than trying to do it yourself and not quite doing it right or missing times or not putting the right information in when you've got a timeline and then having to try and fix it up down the track.
Mm. Now, what about the dispute assessment? I mean, I imagine often that would involve some expert witnesses. It might involve other experts from inside a law firm, etc. I mean, how do you go about that process, and is it time consuming or can it be quick?
Look, it just depends on the nature of the dispute. So we'll usually meet with the client, whether in person or over video link, to get their side of the story because I find when we talk to someone, we actually get a lot more information. Then we get the documents to back up what they're saying and we can test what they're saying and get a pretty good feel for if they've got a strong or weak case. And then once you've sent a letter of demand, when you get a response, often the other side of the story will be told, and that will then feed into the assessment of the strategy and the prospects of success.
Mm. And so when you're working out the strategy, is part of that determining, what's a suitable outcome or an acceptable outcome versus what's the ideal world?
Absolutely. And in fact, often when I first meet with someone, I say, what what are you wanting to get out of this? Let's go to the end of the story and work our way back. And I'll tell you if it's the never ending story or something impossible, or if it is actually realistic and work our way back and how we're going to achieve it.
Is it also what they're happy to live with?
Well, that's right. I mean, if often I say to people, you it's going to cost you X dollars to go through. Say you go through the whole process and it never settles, and you go all the way to trial. It's going to cost you X amount. Secondly, does the person on the other side actually have the funds to pay that? 'Cause it's nice to get a piece of paper, but
Yeah.
yeah, it's nice to get a piece of paper at the end of it, but if you're not going to get anything out of it, it's a waste of your time and money. And thirdly, often if you settle now, you take a little hit now, you essentially buy your certainty. You buy certainty, you buy not having to go through the process, you buy not having to have all those legal fees, it's often worthwhile.
Yeah, it's about when do you actually cut off and say, "Yeah, that's an acceptable thing, we can walk away with that." So what about the next parts of the process? So if we've done our negotiation, our mediation or arbitration, and we've got past that and didn't work and we're under the well, arbitration, of course, would work, but if we go through those things and we're gonna go to court, I mean, what do we do then? I mean, it's a big step from there, isn't it, to get everything ready and then to obviously find your barristers and all of those sort of things?
It is. You want to put your best foot forward. So when you're heading off to court, information is king, evidence is king. So the more information or the more evidence you can collate early on and give to your lawyers, the better, because then they can frame the case the way that suits the evidence and suits the law. And they can also help you with strategy because the negotiations don't stop just because you've started litigation.
Yeah. Now, if we end up with a negotiated solution, I mean, it's probably up to the two lawyers on either side to come up with the documentation.
Yeah, absolutely. We do what's called a deed of settlement, and it sets out everything that both sides are required to do, and providing releases and everything that needs to be done to protect both parties.
Yep. And when the court makes the decision, I mean, how does that part of it work?
Well, when the court makes a decision, you have your trial, and it may be some months later that you get your decision. You get called in, you get told maybe the night before, maybe a few days before, decision's coming down. You go to court, and there's usually a written decision, and often it just depends what type of case is, but often it's all or nothing. So you've either won or you've lost in most cases. Some cases there might be apportionment, but in most cases you've either won or you've lost. And if you've lost, then you may have to pay a portion of the other side's costs. If you've won, you may get a portion of your costs paid. But then everyone looks at appeal. The person who's lost is whether there's an appeal point and whether they want to appeal, whether there is an actual appeal point, because there's limited issues that you can appeal.
Yeah, you can't just appeal because you're unhappy. You've got to have a point of law or something along those lines. Yeah,
Yeah, that's right. That's right. It certainly can't just be that you didn't like the decision. That's not an appeal point.
excellent. Well, I think the most important message I get from this is if you getting your letter of demand or you think you're in trouble, pick up the phone
Absolutely. It will save you a huge amount of time, costs, effort. Absolutely.
and stress.
And stress. Absolutely. Yeah.
Beautiful. All right, well, thanks for that, Catherine. We'll come back with another topic soon.
Thanks, Andrew.